Hope you enjoyed lunch. Now we will begin the second session of the 2024 International IP Court Conference. And in this session, we will be covering the doctrine of equivalence, approaches in different jurisdictions for substantial patent protection. Judge Jung Taeksoo of IP High Court of Korea will be moderating the session. Hi, thank you so much for the introduction. Nice to meet you all. I am Judge Jung. I am excited to be moderating this session. It's an honor. And the topic of this session is Doctrine of Equivalence. And this topic is such an important topic for the legal practice, and I would like to introduce our panelists for you. Please give them a big round of applause. First of all, we have Judge Amano Kenji of IP High Court of Japan. And next, we have Judge Rian Kalden of the second panel of the Court of Appeal, UPC. And we have Judge Richard Meade of High Court of England and Wales. We have former Chief Justice of the U.S. CAFC, Mr. Randall Rader. And we have Judge Valerie Thean from High Court of Singapore. And lastly, we have Judge Kisu from Intellectual Property High Court of Korea. Thank you. And we sometimes have to cut losses in our life, and there are things that we will need to always cut for our health and beauty in our life. What would that be? That's callous. So please give us the hypothetical case. Okay, you're looking at it right now on the screen. So we have prepared a hypothetical case. And this invention is called a callus remover with microcutters. And this hypothetical case is on a patented invention related to it. So the microcutters here are important. The feature of the microcutter is that it is shaped like a gourd. So the shape of the microcutter is specified as a gourd shape where two circular sections overlap with a concave middle. And the defendant's product has a circular shaped microcutters, which is on the right. So the left one is the patented invention and the right one is the defendant's product. And the dark highlighted area is the cutter. So in the patented invention, there are two protruding points where the cutting begins at two locations, and there is a concave middle, right? And there you have additional cutting thanks to the shape of the microcutter. And in this hypothetical case, the gourd shape or the circular shape is used for the microcutters, and these are quite new shape for the microcutters. And if you look at the reference book in front of you, the booklet in front of you, you can find it at 117. And if you look at it from the paper, it's 119, page 119. So please refer to those pages when you're looking at it from the booklet. And we do have a survey for you regarding this hypothetical case. So this patented invention, do you think that the defendant's product constitutes an equivalent infringement on the plaintiff's patented invention? And if the gourd shape is the defendant's product and the circular shape is the plaintiff's product, then would the result change? So please join the survey now by using this QR code on the screen, and there you will be able to give your answers by clicking on the options that are provided on the survey form. So please click those so that we can check your views on this case. And if you change your mind in the middle of the session, you may redo it. You can cancel, withdraw your answer, and re-answer. And at the end of the session, I will ask the same questions to the panelists as well. And you don't have to feel pressured because I'm just asking for your off-the-cuff answer. And I am very curious to see how our audience is going to view this case. And during the session, please feel free to answer in the survey. But there's one thing that I want to remind you. This is really only to pique your interest and get you engaged in the session after lunch. So please do not dwell on it too seriously, okay? And do not try to engage in very serious discussions amongst yourself on this hypothetical case. Then let us move on to the panelists' presentations. We have prepared 8 different questions, and the panelists have answered these 8 questions in earnest, and some of the members have prepared the presentation materials as well. And the detailed answers to these questions are already prepared in the booklet, so you may be able to refer to that at your convenience. And we will be having the session in 4 different parts, and we will be grouping 2 questions in one part. So we will be, getting the answers from Japan, UK, US, and Korea. And Judge Rian Kalden, and Judge Valerie Thean have prepared presentation materials. So those presentations will be put in the middle of the different parts. And before we kickstart the session, I'd like to ask our panelists for their understanding for the limited time we have. And I would like to ask for your understanding from the audience as well on that note. And I'm sure that you have questions from the floor, and those will be dealt with at the Q&A session at the end. So let me ask the part 1 question. So I'd like to ask our panelists to tell us about your respective country's equivalence test and what each element in the test means using examples or precedents. Also, please tell us if your country's equivalence test is closer to the element-by-element analysis or the invention as a whole analysis, and share any relevant cases. And you have 4 minutes each for your answers. Let me first start with Judge Kenji from Japan.
안녕하세요. 일본 판사의 아마노 켄지입니다. Okay.
I'm Amano Kenji, judge from Japan.
All right. Although we don't have any black letter law, that means statute of doctrine of equivalence, but as I described here, we have a Supreme Court case in 1998. It is greatly influenced by United States Court decision. But when the defendant product has a different part from the patented invention, when the 5 requirements are met, the defendant product will be rendered as infringement or as equivalent. The first, the difference between the claimant patent and the defendant product should not be the essential part of the invention. The secondly, the defendant product should enjoy the purpose and function and the effect of the invention. And the third, the defendant product should have been easily it would have been easy for a person of the skill in the art to conceive the idea of replacing the lacking part from the invention to make a dependent product. That's the third point. Fourth, it should not be on the public domain at the time of filing. And the fifth element, fifth requirement was no special circumstances such as kind of prosecution history stoppel. And that's the answer for the question 1. And the second question, for the second question, we have a Supreme Court case in 2016 called Max Callisto case, written in my description. But because time is limited, we are looking at the concept of the invention, not the every single element of the invention, but the total concept of the invention. So I'd like to answer whether we apply which principle we applies invention as a whole approach. That's it from now. Thank you.
네, 감사합니다. 아마노 켄지 판사님.
Thank you. And next, I would like to ask Judge Richard Meade to give his answer, please.
Thank you very much. I'm honored to be here. This is my third time attending this conference, but my first time in person. And I'm delighted to be talking about such a fundamental topic to patent law, and I think also one of the most interesting topics to discuss internationally and to compare our different approaches in different jurisdictions, and also a topic that's key to balancing the interests of patentees and defendants. The UK has always considered the topic of equivalence within the law of infringement of patents, but it's only since our Supreme Court decision in the case of Activis and Lilly, and the reference to that is given in full in the conference materials, that we have started to describe equivalence as being the subject of a truly separate doctrine. And we answer the question of whether there's infringement by equivalence as follows. First of all, we work out what the ordinary meaning of the claim is, and then having done that, we ask whether the variant infringes as an equivalent using 3 questions. I won't read them out in full, they're set out in the very helpful conference materials, but paraphrasing a little bit, first of all we ask, does the variant work the same way, by looking at the inventive core of the invention. Secondly, we ask whether it would be obvious to the skilled person that the variant works the same way. And thirdly, we ask whether there is some indication in the patent to indicate that the patentee intended to have a narrow claim scope rather than a broad one. And depending on the answer to those questions, we decide whether or not there is infringement by equivalence. We answer the questions claim element by claim element. In other words, it's necessary to find, with respect to each element, that there is either normal or equivalent infringement. But in looking at each element one at a time, we require there to be had regard to the overall inventive core of the invention. So although we look at each element one at a time, and although it's requirement that each element be found, we try to do it in a unified way with a single consistent regard to the inventive core of the invention. And we thank you for your attention. That's the UK's answer to questions 1 and 2.
네, 리차드 미드 판사님 감사합니다.
Thank you. So in the in the UK, I have a question. So after the vector-based judgment, the improver-related judgment, the big framework would be still maintained, and you're seeking the doctrine of equivalent with that as a backdrop. Is that the case?
Yes, thank you. That's a very good question. The answer is essentially yes. We've always had a 3-question approach, which is almost always used, although not mandatory and not part of the statute. And previously that was in the improver questions. that was looked at by our House of Lords, our Supreme Court, in a case called Amgen, and then it was reconsidered by the Supreme Court in Activis and Lilly, which rephrased some of the questions and reorganized the questions to give effect to a separate doctrine of equivalence. But you're absolutely right, the overall analysis is very similar to what we've had since the improver questions in the 1990s.
네, 고맙습니다.
Thank you. And I would like to ask Mr. Rader to give his answer, please.
Yes, the United States uses a rather simple, straightforward test of whether there is substantially the same function, way, and result in the equivalent as in the claimed invention. That always comes down to a question of whether it's substantially the same way. The result and function are almost always synonymous. This is found in the case of Warner Jenkinson, and we have revisited the doctrine of equivalence, looking for its fundamental underpinnings, and determined that really the one purpose it performs is to protect a claimed invention against after arising technology. If you have a new technology which changes the terms of a claim, then you can still protect the invention even though its claim terms have been changed by the after arising technology. We enforce this on an element by element basis. There's a little contradiction in that, because that asks us to look at whether there's a missing element. Well, the whole test of the doctrine of equivalence is whether there's a missing element from the claims. And so the element by element approach really performs one function in U.S. law, and that's to convert the question of doctrine of equivalence from a question of fact that the jury would look at to a question of law which the judge can decide on summary judgment. And most often it is decided on summary judgment on an element by element approach, finding that the way is not substantially different. Thank you.
네, 감사합니다.
Thank you. And now I would like to ask Judge Kim to give his answer. Thank you for the question. We have many people in the room, and I'm sure that you're very much familiar with the doctrine of equivalence that is applied in Korea. But we also have international panelists here and other esteemed guests here, and we are hearing from many different countries as well. So this would be a great opportunity to make comparison amongst different countries. So this would be a good chance for you to reflect on our doctrine of equivalence and maybe think about how to improve it even further. So when it comes to the DOE in Korea, as you all know, we look at the technical core and the effect, and if there are any small changes to the claims, we are preventing it from invalidating the whole patent, and the doctrine of equivalence is developed in that backdrop. So for the equivalent infringement to be constituted, you have to have the same core, and we call it the identity of the problem solving. And thirdly, changing the elements should be very clear to the Fuzita, and we actually consider those three factors as the important criteria of the DOE. But if we are only looking at those three factors, then in some cases there could be cases where the protection is given to the knowledge that was already in the public domain, and there could be some cases where the claims are ignored on an unreasonable basis. So that is why it can lead to the infringement upon the rights of the third party as well. So we will need to consider those public value as well. And we will also need to consider the trust level of the third parties as well. So from those different aspects, we will need to set the right criteria. And in that sense, the DOE in Korea also include the additional factors such as it shouldn't be the free-to-use technology, and it shouldn't be it shouldn't be intentionally excluded from the claims. So if the technology is already easily obtainable from the public domain, which is that it is a free-to-use technology, then it will need to be considered as a factor as well. And for the items that are intentionally excluded by the patent holder, it should be considered as part of the DOE consideration. And it is a very tricky question whether we are looking at it element by element or the invention as a whole. But the important thing here is that the patent and the changes to the elements will need to be looked at together. And if there is nothing, then there is no room for the equivalent infringement. So the equivalent level between different factors will have the room to be explained as the element by element analysis. But when it comes to the actual practice, the same identity of the problem-solving mechanism and the identity of the technology and the effect will need to be looked at together. So at the level of the way of the problem solving, we are actually looking at it from the invention as a whole. Thank you. Thank you, Mr. Kim. I should be managing the time wisely, so I should keep it to myself, but I really do have one question to Judge Amano. Kenji, I mean, as you know, we have many different similar doctrines. I mean, of course, there are different legal differences, legal framework differences across different countries, but then in Japan, we do have a lot of similarities. So let me ask you this question. So when it compares to the prior art, if there is not a big contribution to the development of the technology, then it is unlikely that it will constitute a equivalent infringement. Is that the case? And if the contribution level is continuously evaluated, then before the evaluation is complete, then the dependence products detailed analysis cannot be done in advance. Isn't that the case? What do you think?
You're asking that the patented invention is little contribution to the prior public domain. What happens if the patentee argues the doctrine of equivalence? Is it okay to do that?
So, for example, in the Mikatato case, according to the doctrine that was used there, you are considering the contribution to the technological development. And before you make that evaluation, how much of the contribution there was, you cannot make a in detail analysis of the product level. Isn't that the case?
Actually, I'm not sure I just articulate your question well, but if the contribution of the invention is not high, that will make our I'm sorry. I have to think about that. So answer later.
I'm sorry. 정말 죄송합니다.
I don't understand you.
이따 또 한번 같이 얘기해 보기로 하죠. 네, 그럼 감사합니다. 자, 이어서 파트 2로 넘어가겠습니다.
Okay, thank you. I mean, I'll ask you the question later, separately. And moving on to the part 2. So, what is the sequence? So, when assessing equivalence, how do your courts consider prior art? Do they, in practice, differentiate between prior art? Sorry. I mean, in the equivalence test in your jurisdiction, what is the sequence like? What is the sequence between assessing whether the effect is identical and assessing whether the problem-solving mechanism is identical? And also, do your courts consider the knowledge and skill level of a fusita? If so, which requirement of equivalence test is related to the fusita? And what is considered the relevant date of assessing such aspect?
So, Judge, from Japan, Judge Amano, you can go first, and you have 3 minutes.
Okay, the first question is is there any separate step determining the solving the problem or the result? Okay, as I explained that the first requirement we look at the inventive concept, what is the essential part of the invention. And the second step is we look at the result, function, and the effect of the dependent products enjoyed, whether the dependent product enjoyed the function and the effect of the invention. So there is a separate step, but it is closely related. So if the requirement 1 is meted, usually the second requirement will also meet it. And the second question would be the relevant date. So our third requirement looks at whether the dependent product is easy to make at the time of infringement date from the patented invention. And the fourth requirement is when the time of the patent filing that the dependent product would be a public domain. So that's my answer.
네, 고맙습니다. 네, 이어서
Thank you. And I'd like to ask Judge Richard Meade, please.
Thank you very much. So, in relation to question 3, the result and the way of achieving it are both considered together within question 1 of the activist and Lily questions that I paraphrased earlier. And I respectfully agree with Judge Amano that these two are very closely related and sometimes quite difficult to distinguish. But in any event, as a matter of doctrine, we look at both of them together within activist question 1. In relation to the timing of the equivalence determination, I think this is a particularly important and interesting question in the context of the purpose of looking at infringement by equivalence. In general, in English law, we determine the meaning and validity of the patent at the date of the patent, at the date of application. But we don't apply that principle inflexibly, and it's become apparent to English and European patent law over time that trying to assess equivalence without reference to information available at the time of infringement is unfair on patentees, especially because it deprives the court of the opportunity to consider the effect of inventive improvements. So in relation to the law of equivalence, the activist questions in UK law permit the ordinary skilled person to be told that the alleged infringement, the variant, does in fact work, even if that's not information that would have been available to them at the date of the patent, and even if it's not something that they could work out for themselves using their common general knowledge at the date of the patent. and this allows, in appropriate cases, for the patentee to succeed when the equivalence question concerns technology that was only developed after the date of the patent. So the answer to question 4 is generally the time of equivalence is the date of the patent, but for inventive variants in particular, it's permissible for the person skilled in the art to be given information that's only available at the date of infringement. Thank you.
네, 미드 판사님 감사합니다.
Thank you. And I'd like to ask Judge Rader for his answer, please, from the U.S.
We are examining the accused product or process in comparison to the written claim language. And we're looking to see primarily if the accused product uses substantially the same way of solving the problems. Most often this issue gets decided in the U.S. courts based on some exceptions to the doctrine of equivalence and whether they exist. And the primary exception is prosecution history estoppel, which means if you have changed your patent by amendment during prosecution to avoid prior art, that you cannot recapture any subject matter that you surrendered during the prosecution process. So that does relate the doctrine back to prior art as we discern whether there has been any surrender of claimed subject matter which then cannot be recaptured using the doctrine of equivalence. We perform this analysis at the time of infringement. So that would come at a point later when the infringement has occurred.
감사합니다, 레이더 판사님.
Thank you. And lastly, I'd like to ask Judge Kim. Thank you for the question. Listening to the answers, I think the practice of Japanese judiciary is quite similar to the Korean one. And in Korea, we are looking at the identity of the way of the problem solving. So even though the effect is the same, if that is not based on the same problem solving, it's not going to be the identical or the equivalent one. And there are 5 different standards. There are 3 affirmative factors. These are independent standards, so we cannot really view that there are sequences between these 3 factors. But then in practice, we look at the identity of the problem solving and the identity of the effect, and we are looking at the ease of substitution. That is the sequence that we look at. And the third one, the ease of substitution, and the 4th factor, which is it shouldn't be the free-to-use technology, are important factors that we consider as well. And the ordinary skilled, Fosita's skill level, we are looking at it from a very sophisticated timing perspective, but then according to the Supreme Court ruling, it should be based on the core of the technological invention. Thank you. Thank you, Judge Kim. So I would like to, ask the audience to give our panelists a big round of applause. And when a moderator asks a question out of the blue, that would, put the panelists back, so I'm sorry about that. But I mean, DOE is such an important topic, but we get drowsy sometimes. That is why we have prepared this hypothetical case. I am sure that you have, gone into the survey screen and checked your answers, but then if you haven't, please do so by going into the survey and checking your answer. And next, we will be hearing from Judge Rian Kalden from the UPC. We will be hearing her presentation on the European DOE. Judge Rian Kalden, please go ahead, and you have 15 minutes for the presentation.
Okay, thank you so much. And I'll try to cover a few of the main jurisdictions in Europe on the doctrine of equivalence. But mainly, I'll try and find some common features of those, which might give you a hint as to where the UPC might go in the future, because we haven't had a case to establish the doctrine of equivalence in the UPC yet. Equivalence is a matter of claim construction. As a general principle of claim construction, the scope of protection of a patent must correspond to its contribution to the state of the art. And this principle is basically laid down in Article 69 of the European Patent Convention, which says that the extent of protection conferred by European patents shall be determined by the claims, but nevertheless the description and drawing shall be used to interpret the claims. Now, this was applied quite differently, especially in the continental Europe and in the common law applied in the UK. In UK, much focus was on the literal wording of the claims, whereas in Germany and other countries such as the Netherlands, there was more focus on the inventive concept, where the claim was rather sort of guiding as to what you would gather from the description that the patentee had meant to cover. So there was a protocol set up to bring these interpretations together. And the protocol says that a balance must be found between a fair protection for the patentee with a reasonable degree of certainty for both parties. So I'm trying to get further than this. Yeah. So now there's a two-step approach to determining the scope of protection. The first step is that you interpret the claim on its wording, but purposively. So you look at, from the standpoint of the person skilled in the art at the priority date, what is the technical function of each element in the context of the overall teaching of the patent, taking into account the description and the drawings. And this exercise entails that you look at what is the essence of the patent, what is the core, what is the inventive concept. There's many ways of saying this. And then the patent is infringed literally when all elements are realized in the attacked embodiment. Now, if the attacked embodiment or method varies from an element specified in the claim, it could still be infringing if it is equivalent. And this doctrine, which is also laid down in the protocol to Article 69, is the same for all type of patents. But it's fair to say that for some
Excuse me, Rian Kalden, close. More closer.
Oh, sorry. But for some type of patents, it is probably more difficult to satisfy the requirements, such as, for instance, parameter claims that usually have a rather limited scope. Now, I'd like to present a very old a case, which is shown here on the screen, which on the left is a drawing from the patent specification, but I've given you the embodiment in accordance with the patent, which is called the epilady. And at the right side, you find the smooth and silky embodiment, which was by Improver. Remington. Now, the patent covered a helical spring, a curved helical spring driven by a motor, and when rotated, it would grip the hairs between its coils and then pluck the hair from the skin. Now, the infringement didn't have the words helical spring. It didn't have that in its embodiment. Instead, it had a rubber rod with slits. But when rotating, it also gripped the hairs and plucked it from the hair. And for this technique with the rubber rods, it also obtained a patent. And this case was run in several European countries, such as the UK and Germany, and also the Netherlands. And then the question is this infringing under the doctrine of equivalence? So while you think about this, I'll go into the theory, and then I'll give you the answers later. So in Germany, Germany has a very long-standing doctrine of equivalence, and they have 3 questions to which the answer has to be yes, and there's 1 defense. So the first question is about the same effect, gleiche Wirkung, and that is asking, does this alternative feature solve the problem underlying the invention having the same effect as the feature in the claim? And the second criterion is obviousness. So would the common knowledge of the person skilled in the art would have enabled him to find the alternative at the priority date? So would the person skilled in the art think this alternative would indeed have the same function and effect? And the third question is a bit of a mysterious question, but I think it comes down to the question whether it falls within the same inventive concept of the claim. And the defense is very close to what we heard from Korea and Japan, so the free-to-use technology. So the question is whether the embodiment that is attacked in itself is would be a patentable invention or not in view of the prior art. Because you cannot, of course, cover something that is already within the prior art or is only a non-inventive alternative thereto. And a very similar squeeze non-infringement argument is also known from the UK as a Gillette defense, and that's also recognized in the Netherlands and in practice in France. So basically this argument goes as follows. The attacked embodiment is a non-inventive variant or already belongs to the state of the art at the priority date. So if that's the case, then the claim is interpreted broadly so that it covers the attacked embodiment, but then the patent must be invalid for lack of novelty or inventive step as well. Alternatively, the claim can be interpreted limited in scope and still be valid, but then the attacked embodiment is no longer infringing. So in other words, an equivalent product or process must be inventive in relation to the prior art. In the Netherlands, we have a very similar concept, but these questions are more phrased along the orientation which is set out in the protocol. So the first question is about the technical equivalence. The second looks at whether there is a fair protection for the patentee, which is the case if the inventive concept is sufficiently broad so that the alternative embodiment and the product with it still falls within that same inventive concept. But there also has to be reasonable legal certainty for third parties. So if the person skilled in the art sees good grounds to assume that the patentee actually wanted to limit its scope, then the attacked embodiment cannot be an equivalent. And finally, also, the equivalent element must be new and inventive over the prior art. So we also recognize the Gillette and Formstein defense. Now, the UK I'm not going to discuss, and France neither, because I now want to come to the common elements, which is that all of the doctrines in Europe look at the question whether the attacked product with the deviating element from the perspective of the person skilled in the art solves the problem underlying the claim and performing the same function in achieving the solution. And also quite important is that the attacked embodiment must within the scope of the teaching of the claim. So what problem is solved and what does it contribute or add to the prior art? And it must essentially have the same effect as the element mentioned in the claim. Now these are all cumulative requirements, and it doesn't really matter in which order you answer the questions. And I would say it is more an invention approach rather than an element by element analysis. As to the criteria of the obviousness of the variation, so that it must have been obvious to the person skilled in the art that the alternative is an equivalent means. Why is that so? Well, if the person skilled in the art could not at a priority date have found the deviating element for achieving the underlying problem, it takes an inventive step to do so, and then it's not justified that this is covered by the scope of protection of the patent in suit. So in other words, the equivalent must be obvious in relation to the claimed product or process. I think I'm going to skip the question about inventive equivalence. We may come back to this later on, although it's an interesting question. As to new developments, so variations that rely based on developments occurred since the priority date, Richard Meade already referred to his so-called unforeseen equivalents. They still may be taken into account even though these cannot be obvious at the priority date. And there's two ways of achieving this. The first option, which is used in the UK but also in Germany, it is hypothetically assumed the skilled person was aware of the variant and must be examined whether he would have considered it as an equivalent substitute. Or, and this is the approach in the Netherlands, the obviousness question is answered as at the date of infringement. The third question, the orientation towards the meaning of the claim in Germany, or strict compliance with the language, or the variant must be within the teaching of the patent in the Netherlands and France, leads to similar guidelines. So there is no equivalence if there are indications that embodiments should, outside the literal scope, are not meant to be protected, because, for instance, a selection has been made, or the skilled person would have concluded that strict compliance with the literal meaning is an essential requirement. But there is room for equivalence if the teaching of the patent is clearly broader than the wording of the claim. Furthermore, if several possible embodiments are disclosed in the description, but only one is included in the claim, then we have the dogma of disclosed but not claimed is disclaimed. And if the patentee limits an initially broader patent claim to specific embodiments, and there are indications that the claim was limited to distinguish it from the prior art, there can also not be equivalence. Now, looking at the Epilady case, so in Germany and the UK, the same effect and result, which was obvious to the person skilled in the art, was accepted by the court, but then there was a deviation. In Germany, it was found that the inventive concept behind the Epilady case was broad enough, it being the general concept of using a flexible cylinder with openings that may easily and efficiently pluck hair from the skin. So rubber rods with slits was covered by this general teaching. Whereas in the UK, it was said that the concept of the claim was confined to using a helical spring. But I think it is fair to say that nowadays, I think in the UK, if this case was tried again, it would have found for equivalence. Finally, as to the prosecution history, there is some divergence in Europe as to whether this is done. Of course, in all countries, the patent specification is looked at. In many countries, also in Germany, the published patent application is looked at. So if you compare the patent specification with the original application, you can see what has been amended. And documents from the granting procedure, they can be looked at in the Netherlands and in France. And as a general rule, amendments to distinguish the patent from the prior art may limit the scope of protection. But amendments to overcome formal issues, such as edit matter and clarity, should not affect the scope. In the UK, there's a cautious approach, only if it's truly unclear and the file is unambiguous and may resolve the point. But I'm told that in practice, actually, it never happens that the case turns on looking at the prosecution file and is not in practice looked at. In Germany, it's also not allowed, but their statements in the prosecution file, if brought into the proceedings, can be taken as an indication as to how a person skilled in the art would have interpreted the patent claim at the priority date. So in Germany, basically, they look at the file, then they don't say they look at the file, and then still decide on the basis of it. So that's it for Europe. Thank you.
네. 네, 리안 칼든 판사님 감사합니다.
Thank you, Judge Kalden. And I received a very quick notification from the staff members. I mean, if you go into the survey, you do have a submit button on the bottom. So if you don't click the submit button, if you don't click the submit button, your answer will not be submitted. So do please click. Do click the submit button. And there is another notice. The panelists, I would like to ask you to speak closer to the mic so that we can offer better sound quality for the audience joining online and in the room. And moving on to part 3, let me ask you a question. So, when assessing equivalence, how do your courts consider prior art? And do they, in practice, differentiate between prior art disclosed in the patent specification and prior art not disclosed in the specification? And when it comes to the prosecution history, under what circumstances does the history influence the determination of influence? And when it comes to the reduced amendments, what kind of decisions are made around that? And if there's no amendment, would there still be covered by the doctrine of prosecution history estoppel? And I would give 3 minutes for each panelist to answer. First, I will start with the Judge Kenji from Japan, please.
Okay. Also, it is not limited to prohibited to parties to file other prior art not described in the specification, but the court tend to take much emphasis on the prior art written in the description. But it's not prohibited to parties to file another prior art when determining the factors, the requirements of the doctrine of equivalence. So that's the answer for the 5th question. And then next, the prosecution showing history. We have a Supreme Court cases in 2017, which is on the material, and the code says that the claim of equivalence should be barred when the patentee has intentionally exclude the sort of scope from the claimed invention, which is should be ascertained when the applicant objectively and visibly indicate his and her intention of omitting patent claim from the patent claim while recognizing that the above-mentioned composition could substitute for the patent. So Japanese court looks at the prosecution history. So, for example, there is some embodiments or some drawings in the specification, but the applicant failed to claim it up. So they will be barred from the equivalent. So that's the answer.
네, 감사합니다. 아마노 켄지 판사님.
Thank you for your answer. And next, Judge Richard Meade from the UK, please.
Thank you very much. First of all, any prior art can, of course, be used to attack the validity of the patent, but I will focus on the importance of the prior art to equivalence and infringement. First of all, in the UK law, prior art that is cited in the patent specification can be used to interpret the claims on the theory that the patentee is unlikely to have intended the claims to mean something that covers the prior art. So that's a question of claim interpretation. Secondly, prior art can limit the doctrine of equivalence according to what's sometimes called the Formstein defense after its development in Germany. And I won't say anything more about that because Judge Kalden already covered that in her excellent presentation a few minutes ago. And then thirdly, we have the prosecution history, where it's right to say that in UK law it has a limited role. Where it does have potential effect, it doesn't depend on there having been claim amendment. It is in theory possible to have an effect of the prosecution history arising not from an amendment but from a statement from the patentee about what the claims mean or cover separately from amending the claims. But as I've said already, in fact prosecution history has a limited role in the UK. This is an area where there is, as Judge Kalden also rightly said, quite a lot of difference in some of the nations of Europe. And I hope that quite possibly with the development of case law from the Court of Appeal of the UPC, we in Europe will be able to move to a more consistent position over time. But that's for the future, and the position for the UK as it stands at the moment is what I said 1 or 2 minutes ago. Thank you.
네, 네, 감사합니다.
Thank you.
자, 이어서
And moving on to Judge Randall Rader from the US, please.
The prior art does not play a direct role in the analysis of infringement, instead falling on the side of validity determinations. We do have a doctrine that says if the doctrine of equivalence expands to a point where it encompasses prior art, then that could not be allowed because you could not have gotten the patent in the first place. You cannot use the doctrine of equivalence to expand what you could not have gotten in the first place. The doctrine of prosecution history estoppel is much more prevalent in the US than in the other jurisdictions. Nearly every patent is amended, and there is a surrender of subject matter. Whenever there is an amendment, you can't apply the doctrine of equivalence to recover any of the surrendered subject matter. And this becomes a prominent part of every doctrine of equivalence case where there have been amendments and they inevitably have some impact on the doctrine of equivalence. Finally, I would note that, like Judge Kalden said, we have a doctrine that says if you disclose the subject matter in your specification but do not claim it, you have surrendered that to the public domain and cannot recover it using the doctrine of equivalence. Thank you.
네, 감사합니다.
Thank you. Next, Judge Kim from Korea, please. I joined the IP High Court in 2006, and back in the days, after the working hours, we used to drink a lot, unlike we do these days. I mean, the senior judges and I went out for a drink, and we would talk about the equivalence. Should it be the invention as a whole? Should it be the element by element approach? And the judges started talking about the detailed, discussions, and that went on to like 5-6 hours. And I would pass midnight and spend time, talking about this equivalence. And I was sitting in the middle, and I was almost drowsing off all the time. And we have asked a lot of questions about that back in the days, and I do remember some of them. And that is related to the element by element, or the invention as a whole, or the timing of the infringement. I mean, is it the time of the infringement? Is it the time of the priority date filing? And is it only the invention or the prior art invention that is specified or disclosed in the specification, or should we also consider the prior art that was known to the public domain? I mean, when we start talking about this, I mean, we tend to go over the same thing when you're drunk, right? So we tend to have a really long discussions about this. And 8 years in now that I think back, most of the answers to those questions were given by the Supreme Court of Korea, and that's quite interesting and remarkable. So the discussions that we had actually went into fruition, and it did render some fruits. And I do believe those drunk discussions were the seeds to the future. Anyhow, I think these are the really fundamental question to the doctrine of equivalence. The adoption of the doctrine of equivalence is about protecting the invention, but it's also about protecting undermining the free competition of the third parties. So we always need to find the right balance. So sometimes people say that it should only be looking at the wording in the specification, but some others say that the actual value of the patent or the invention will need to be looked at very thoroughly. And to look at that aspect, people tend to write down the patent claims in a really exaggerated manner, and so that the patent's value would be evaluated in a more exaggerated way. But in the end, the Supreme Court came to the conclusion that the contribution will need to be playing as a really important factor in selecting or determining the scope of protection. So the identity of the problem solving will need to be a really key aspect of the DOE question. So if you look at things from the abstract level, equivalence tests becomes really easy. But then if you look at it in a very narrow way, the equivalence test becomes really hard to penetrate. So considering the prior art to either evaluate the DOE in a wider way or the narrower way is something that we will always need to keep in mind. And the callus remover case, the hypothetical case we covered, it really depends, I think, on the prior inventions and prior art that was available. In the specification, the inventor sounds like this microcutter is the completely new innovative invention, and the patent holder must have exaggerated in that specification. But then, regardless of the shape of the microcutter, the function, and if the problem solving, the problem that is tried to solve is the same, then there is a room for the equivalent infringement to take place. But looking at the hypothetical case, I mean, there are microcutters in the market, and if the key point of the patent or the invention is the shape in and of itself, then the equivalent, infringement will need to be interpreted in a very detailed, narrow way, which is only specific to the shape of the microcutter. So the Supreme Court in Korea has, used this kind of an approach. I mean, for the large new invention, we are using a wider protection area, and for the, narrower inventions, I mean, we are using the narrower protection area. And when it comes to the estoppel, the range or the scope of the estoppel is also differing. I mean, there are strict estoppels and flexible estoppels, but then in Korea we are using the flexible estoppel principle. So the amendments, reduction, or the increase or the expansion would not be directly relating to the scope of the production, but we will need to consider the different factors holistically. Even if the amendment was made to reduce the claims, I mean, some of it could still survive considering different factors, and we will need to look at not just the prosecution history, but also the post steps like the amendments to apply the estoppel. Thank you. Thank you, Judge Kim, for your answer. That is actually helping me not to ask an additional question because you passed your time. So let me move on to the next presentation, which will be given by Judge Valerie Thean from Singapore. Judge Valerie Thean, please go ahead with your presentation. And you have 10 minutes for your presentation. Thank you.
Thank you. First off, must say thank you for inviting me to this conference. It's such a privilege to be here. So just to explain the Singapore theory, and perhaps maybe just to explain a little bit about Singapore as well, as not many of you might be familiar. In Singapore, the highest court would be the Court of Appeal. It can sit as 3 or as 5, depending on whether they have points of law that they want to deal with. And then below the Court of Appeal, there's the High Court. The High Court has the Appellate Division as well as the General Division, which is where I sit as part of a specialized IP list. And we also hear appeals from the state courts and from IP tribunals like the Intellectual Property Office of Singapore. So to explain, in Singapore we do not yet have the DOE, and what we use, but first before we do that, we have to explain it in the context of the fact that we have a purposive claim construction approach. So it's purposive in that we ask what the skilled addressee would have understood the patentee to have used the language of the claim to mean. Now, so what we have, we followed the old UK approach, pre-activist, and it really talks about the true construction of the claim itself. And the description and other parts of the patent specification form the context and assist in the construction of the claims. So we approach it from the viewpoint of the notional skilled person, taken to be a workman or a technician who is aware of everything encompassed in the state of the art and who has the skill to make routine workshop developments, but not to exercise inventiveness. Now, so the 3 questions would be the improver questions, which Judge Meade has dealt with actually. Does the variant have the material effect upon the invention? If yes, then the variant is outside the claim. If no, then would this have been obvious to the notional skilled person at the time of the patent filing? If yes, then the 3rd question applies. Would the reader skilled in the art nevertheless have intended that that the claim be restricted to the 4 corners of the claim? So those are the 3 questions, and basically the court gives primacy to the language adopted by the person who drafted the claim. It's really a claim construction approach. And so one example is this case where the patent really talked about resin molding, and the patent itself referred to the unit as 5 and then other units as 5A, 5B, 5C. When the defendant was sued, basically the defendant said that, oh, this claim is really about 3 other units, and in total there must be 4 units. But in approaching the construction, the Court of Appeal then held that it's not a literal construction, it's purposive. And basically, when they looked at the expert evidence, they concluded that the 5A, 5B, 5C, that was not meant to be exhaustive, and really it was just an illustrative approach, and the patent was infringed. Now, the Court of Appeal in Singapore has considered the doctrine of equivalence twice. The first time was obliquely and and it was about the U.S. doctrine of equivalence. And when that was rejected, then it wasn't very surprising because the U.S. approach is really a literal construction, whereas in Singapore we adopt a purposive construction. And there was thinking that maybe the purposive approach was really enough. Now, then after that, the UK changed its mind, as Judge Meade has described, and in Lee Touching, the Singapore Court of Appeal considered whether we should go the same way. Now, so the difference in activists is really in this limb B, that even if it's outside the claim, does the variant nevertheless infringe because it varies in a way that's immaterial. So, in Lee Touching, basically the Court of Appeal talked about the different legislative schemes, and really its answer was limited to our Patents Act, and it said that the Patents Act really talked about how claims should be determined at the time the claim was filed and as determined by the four corners of the claim. Now, the Court of Appeal also had some other reasons. Basically, they felt that it is fair for a patentee to be bound by the language in which he has drafted his own claim. And they also thought that if you apply the purposive approach, it caters to most of the limitations of language. And basically, they felt that you need to strike a balance between the fair protection to the patentee and secondly, the need to provide a reasonable degree of certainty to third parties. And they were concerned that the doctrine would cause undue uncertainty, and they felt that the purposive approach gives rise to greater certainty because whatever it is, you fall back on the claim. And the DOE brings an element of ex post facto analysis. So actually the Court of Appeal really left it to Parliament, whether Parliament wanted to change the Patents Act. But then the question still remains whether certainty and fairness would be enough or not. So there is a difference in the approach, right? Because if you see from the activist case itself, it could well be that it is within the four corners. It is not, this new pattern may not be on the four corners of the claim, but it could be something that would be considered non-inventive. Because in activists, the primary claim was for the use of a particular chemical, and the respondent's products replaced that chemical as the active ingredient with other compounds that were similar. So it's an issue for discussion even in Singapore whether the Patents Act should be amended. So thank you.
네.
Thank you, Judge Valerie Thean. So the UK has gone through some changes with regard to the DOE, and watching how UK moves, different countries are looking at it cautiously to make research, and Singapore is one of the. So it is such a meaningful occasion that we can watch those two countries in one setting. And let me move on to the next part, which is part 4, and let me ask you this question. So we have the numerical limitation inventions and parameter inventions, and there you have the numerical numbers. And how does your jurisdiction determine whether an accused product that exceeds the numerical range specified in the claims constitute infringement under the doctrine of equivalence? So if the numerical range is exceeded, how do you judge based on the doctrine of equivalence? And if you have any cases with regard to that, please share those examples. And if you have any additional thought that you would like to share with regard to the DOE, please share them. I will give 2 minutes each to the panelists, and we will start from Judge Kenji from Japan.
All right, 2 minutes, okay. We don't use difficult approach depending on the type of invention. But generally, about numerically limited inventions, as I described here, courts are reluctant to apply DOE in such sort of invention, because there is the mindset that such invention are patented by its parameter itself. So the scope of them is very clear cut. So there is very interesting case in Osaka this year. So the UV absorbers molecular weight was 699.99, and while the patent composition was over 700. And it's not direct infringement, and it's not equivalent. This case is appealed to the IP High Court, and the judgment will be rendered maybe soon. So as this example shows, courts are not reluctant to apply doctrine of equivalence so frequently. I don't know why, but maybe it's. I'd like to hear about what is happening in the other jurisdictions. Thank you.
네, 네 감사합니다.
Thank you.
영국의 리차드 미드 판사님.
And Judge Richard Meade from UK.
Thank you very much. In principle, the activist questions can apply to all kinds of claims, and in fact, as far as I know, they have been applied to all kinds of claims. But in a limitation to that statement, the third question in activists allows the type of the claim to be considered in deciding whether the patentee deliberately intended a narrow scope, and with numerical ranges in particular, and especially where the range constitutes the inventive concept. As Judge Amano said, then I think it is likely that those kinds of claims will not be very subject to the doctrine of equivalence. Thank you.
네, 감사합니다.
Thank you. Now, Mr. Rader from the US, please.
Yes, the Warner-Jenkinson opinion actually did deal with a numerical range, and the court permitted the equivalence analysis on that, but narrowed it so considerably using both prosecution history estoppel that it makes it very difficult to see how equivalence could apply if there's been any amendment to the range. And further, if you vary from that numerical range, it becomes very clear that you have exceeded the claim scope of the invention, and it becomes very difficult to say that that's the same way. You've actually done something other than the same way by exceeding the claim limitations.
네, 네 감사합니다.
Thank you.
김기수 판사님, 부탁합니다.
Judge Kim, please.
감사합니다. 일반론으로 말하면
Well, let me touch upon the general concept. So numerical limitation invention does not apply with the DOE. I mean, we cannot say that. Whether it is the numerical limitation invention or the parameter invention, I mean, they would need to go through the same equivalence tests as other cases. But if the numerical limits do have the technical meaning, then when the range is exceeded, then there is a higher room for it to be considered a different invention. That is why it is very likely that the equivalence test would not be met. But then I do have a case that I quoted in the booklet. So this is related to a pharmaceutical item.
그 찬성
So even in the strong acid condition in the intestine, it will be still, absorbed, and even at the bottom of the intestine, it will still be absorbed. And the pattern was designed in a way that the absorption will be happening in both ways. So the top part of the intestine and the bottom part of the intestine, they check the pH level of the acidity, and the coating of the medicine was double coated so that it would be once, melted at the top of the intestine and would be melted once again at the bottom of the intestine. So it had the tablet that would be melting in 2 different steps, and that was patented. And this pH level was defined based on the numbers, but the infringing product was exceeding the parameters, but then it had the same sort of a approach, the double coating to have the double melting in 2 different parts of the intestine. So by understanding it from many different factors in that particular case, the key point was not the numerical numbers, but was the method, the double coating that is dependent on the pH level on different parts of the intestine, and the equivalent infringement was acknowledged in that case. Thank you.
고맙습니다.
Thank you.
자, 이제 질문에 대한 패널들의 답변.
We have heard from the panelists on the prepared questions, and I think I, gave a really big question and gave them only 2 minutes or 4 minutes, and I feel very sorry for doing so. And I want the audience to give them a big round of applause for, doing that in such a short time frame. I'm sure that you have submitted your survey result now. I believe that you did. So I would like to ask the panelists on their esteemed thoughts on this hypothetical case. So you do, have the hypothetical case in front of you, and please share your, simple and off-the-cuff answers. Maybe we will start from Judge Rian Kalden from the UPC.
Sure, fine. So in this particular case, there is quite some emphasis on the specific gourd shape. Now, it's very difficult to say what the inventive concept of this patent is, because we're lacking any background as to the patent specification. We also don't know what the prior art is, so we don't know what the contribution to the prior art is, and what the actual problem is that is solved if you look at it from that perspective. But looking at the facts that are given to us, I would say there is so much emphasis on the actual shape, and also the shape from the facts that we are given seems to be quite essential to achieve the effect. That I would say in this case it would probably not be covered, because the inventive concept is limited to the specific shape that is claimed. Do you want me to also reflect on the second question?
네.
Okay.
Yes, please go ahead.
Okay, so then the second question is if the patented invention involved the microcutters and the defendant's product used a gourd shape, could that constitute an equivalent infringement? Well, that's a very interesting question. If you look at the facts of the first scenario, and you look at what does the shape do, and it did merit an invention, then I would say at first glance possibly not, because if you take it from that perspective, it would not be an obvious alternative to the skilled person that this gourd shape would achieve the same result. However, I should note that it's not impossible for an equivalent embodiment to be having a patent itself, but that can only apply if the patent relates to another problem than the problem that is solved by the patent that is invoked. So looking at it again, and the starting point is the circular microcutters. And you say, well, the inventive concept is sufficiently broad to also cover embodiments with other shapes, but doing the same thing. Then it could be said that the infringing product is using the same concept, the same core, the same invention, and then provided that the gourd shape would be an obvious variant to the circular form, it could be held to be an equivalent. And then, for instance, if the gourd shape solves another problem, I haven't thought of any, but if it solves another problem, which is inventive, then it could merit an invention for that aspect, and then it would become a dependent patent.
네, thank you. 감사합니다.
Thank you.
네, 이어서 싱가포르
And next, I would like to hear from Judge Valerie Thean from Singapore.
Thank you. In the handout that you gave us, there was an explanation to the specification. And in that explanation, basically, it says that due to the two protruding points, the cutting begins at two locations, allowing for a broader area of callus removal with a single motion. So the side blades between the 2 points face each other, enabling the smooth cutting callus to gather between the two side blades. So it seemed to me that the main point of this was to have two blades facing each other. So although on first glance, it would, on a literal, if you take a literal approach, then we would say the circular product is not the same as the gourd product. But if we look at this in a very purposive way, it could be possible, and it's not so clear from the details of the circular product, but if the circular product had these two blades that face each other and can be used in the same way, then I would think that it would infringe on the purposive approach, because it would not be a material variation.
네, 감사합니다.
Thank you.
일본의 아마노 켄지 판사.
Now I will ask Judge Kenji from Japan.
Okay. I think it depends on what is written in the specification, but on the premise that the prior art is the razor blade, and this sort of micro cutter plate hasn't been existed before the filing of this patent. It might be that this sort of micro cutter plates is the inventive concept of this patent, so it should meet the requirement number one, and the dependent product enjoys its effect. So I think it would meet the requirement number two and maybe three. I think it depends on what is written in the description, whether the dependent product meet requirement number 415. If there are embodiments of the circular shape, but the patentee failed to claim it up or omitted this sort of claim during the prosecution history, the circumstances might bar the enforcement of the patent. Okay, and the question number two, and in that case, the issue is whether it is easy for the skilled person to modify the shape of blade cutter from circular to gauge shape. So it's a problem of requirement number 4. So whether it is obvious at the time of infringement to modify the shape of micro cutter. So I think at the first glance, I think it's obvious, but there is some sort of inventive step by modifying the shape of the blade it have some sort of technical advance. So it might be meet the requirement for. So when that circumstances, maybe the doctrine of equivalence would apply to that case. Thank you.
Yes, thank you. 감사합니다.
Thank you. And Richard Meade from UK, please.
Thank you very much. Can I first of all say what an excellent hypothetical question I think this is. It's extremely difficult to put together questions like this to raise all these issues in just a couple of pages, and I think it's very impressive. From the point of view of answering the specific questions, even though the United Kingdom is not part of the UPC, I fully and entirely agree with Judge Kalden's excellent answer and have nothing to add.
네. 네, 그렇군요. 감사합니다.
I see. Thank you.
레이더 판사님.
Judge Rader, please.
Yes, I would also see that
마이크
this claim focuses on the gourd shape, the function, result, the way is tied to that gourd shape, and that would probably preclude the doctrine of equivalence. I would add one additional concept which we haven't discussed, which is very close to everything we've talked about, and that's foreseeability. The creator of the infringing product here made a slight variation. That should have been fully foreseeable to the patent draftsman. They should have claimed their invention in terms that would have also encompassed a shape circular, but not with the emphasis on the gourd features. We should not correct claim drafting using the doctrine of equivalence. So when it's foreseeable that they should have claimed it properly in the first place, we shouldn't correct that using the doctrine of equivalence to allow them to get scope they should have claimed in the first place.
네. 네. 네, 감사합니다.
Thank you.
이어서 김기수 판사님.
And Judge Kim?
네, 감사합니다. 이 사례가 굉장히 재밌고
Thank you. This
실제로
example is
각질의
quite fun
길을
to look
길을
at,
해서
and I really hope to use two different types of callus removers myself and use it so that I can see the effect of the two different types to be able to give a clear answer. But anyhow, I mean, we do have the gourd-shaped patent, and we are talking about whether it is equivalent with the circular-shaped cutter. And I mean, as the other judges have said, I mean, we do not have enough information to be able to give a clear answer. So in a specific real case, I mean, it may render a different result, and maybe different people may have different opinions. But then based on my personal point of view, we will need to consider the prior art. The first prior art to the microcutter is the abrasive stone,
너무 힘들다.
and that's too difficult, it said. And the razor blade is very convenient, but when you do a clumsy work, then it will, cause injury. So to address these two concerns, I mean, the microcutter has been invented. I mean, that is what is explained here. If that is all it explains, and if you don't too specifically focus on the gourd shape, then it could have covered a wider scope, but it wasn't the case. I mean, you actually specifically focused, the patent holder specifically focused on the shape of the microcutter and even talked about the specific effect that comes from the specific shape of the microcutter. So the gourd shape of two protruding sides and the concave middle, I believe, is a part that the patent holder wanted to highlight. So I believe that the defendant product doesn't have such elements. So it would be probably negated even at the first requirement. And the effect may not be the same either. In the defendant's product, I mean, it doesn't have the double, sided protruding edges, and that may not result in the additional cutting. But when it comes to the circular shape versus the gourd shape, I mean, there can be some differences between the two. In the specification, the circular shape is not just about the direction of the blade. I mean, it is about, having the same effect across the board regardless of the direction of the blade. So that actually could be, covered. That kind of effect can be effectively covered by the gourd shape. So I believe that the first requirement would be passed, and the second requirement would be also passed. But then the third requirement, which is the obviousness, is something that would be a hurdle. So the gourd shape and the circular shape, in my opinion, the effect will need to be really compared. And I did look at the video of the differences of the effect of the two different types of the shapes, but then it really would be decided differently based on the evidence that is presented to the court. So let me summarize. In the first case, I mean, it would be easy for the DOE to be negated, but then in the second case, it is likely that it would be more accepted. Thank you, Judge Kim. And listening to your answer, I am once again, impressed by this hypothetical case, and I can clearly tell who prepared this because you gave me such an impressive answer. So let me see the result from the audience. A lot of the audience members gave us the reply. Okay, we have 48% that it constitutes infringement and 53% that it does not constitute infringement. Okay, the second question, yes, it is an infringement, 51%. No, it is not an infringement, 49%. Well, I was expecting more tilted result, but there was a comment that this was not a technology that was available in the prior art. So I believe that was the reason why we had a really balanced poll result. And thank you so much for your participation in the survey. Any special comments from the panelists? Judge Kalden, please go ahead.
I would have a comment to Judge Rader's comment, not so much to the case, but to the foreseeability requirement. If I understand correctly, the idea about this foreseeability is that if there is an alternative that is an obvious alternative to the claimed element at the priority date, then the patentee should not be able to claim it because he should have thought of it from the outset. I don't think this is as such the way the equivalence doctrine is looked at in Europe. There is the requirement that the alternative embodiment must have been must have been able to be found, because otherwise the alternative embodiment would be inventive. But it's not that if it's obvious, equivalence would be excluded. Basically, it would be basically the death to the doctrine of equivalence, because then either way it doesn't work. So what is excluded normally is if the description or other indications in some countries are that the patentee actually considered the alternative that would be an obvious equivalent, but didn't claim it. And that can be either by already having it in the description and not claiming it, so then it is disclosed but not claimed, and therefore disclaimed. Or there is a description, there's a whole explanation as to why this particular embodiment, for whatever reasons, is more superior to other alternatives, and then there is a deliberate choice, so that the person skilled in the art considers, well, the patentee actually wanted this particular embodiment to be claimed and no alternatives, that do not have these required specifications that are particularly useful for this invention. So I think that there is a slight variation in your approach as to the one in Europe.
네, 리안 칼든 판사님 감사드립니다.
Thank you, Judge Kalden, for your insight.
함께 해주신 우리 청중
I'd like to thank the audience members on the floor for their presence. And if you have any questions, we would love to hear from you too. And you may have something to say about the hypothetical case and your judgment about the hypothetical case. So if you want to share your thoughts, please raise your hand.
네, 좋습니다. 그러면
Okay.
자, 이제 시간도 되었고요.
Well, but I see no hands in the air, and it's about time. So I think we can close the second session. So Honorable Judge Amano Kenji, Judge Kalden, Judge Meade, Judge Rader, and Judge Thean, and Judge Kim, thank you so much for your time, and I think I will have such fond memories of this session. Please give them a big round of applause, everyone.
진지한 열정으로 함께
And
해주셔서 모든 여러분
I am
감사합니다.
very thankful for all your heated interest in the session. Hope you enjoy the rest of the evening. Thank you. This concludes the second session, and I would like to thank the moderator and the panelists for their active